Hey, Lisa, how are you? Good morning.
Hey, good morning.
Hey, good to see you. Hey, I loved our workshop last week.
Oh, that's so fun. That was, first of all, so great to get off the screen. I mean, we like being on the screen, but really good to be in person and interact with folks on these questions.
Yeah, it was interesting, right? I didn't realize it was going to be part therapy sesh. Like, hey, we need to collaborate as lawyers across the company, and how do we do that? And how do we get budget? And you hear a lot. We hear a lot from business about some of the translation issues, right? Like between, like, hey, you're kind of talking to me about risk mitigation, but I don't quite know what to do with that. And it's always been a little one-sided for me, but actually lawyers are like, hey, it works the other way too.
It absolutely does. And I mean, the therapy session, this is a challenging time. And so I think empathy is really important. And you need to convince other people that everybody should be rowing in the same direction. And how do you motivate? And I think having empathy and really thinking about one of the things we heard really is like, how do you motivate the business? And if you come at it with just saying, this is compliance, you have to do this, the law says, as opposed to saying, really speaking in a business way on how does this support the business and what are all of our, combined objectives and how do we get there and which are the points that the lawyers do, the compliance people do versus the business people do. And I think almost like chess, like strategizing that, you really increase the odds of moving forward in a lot more of an efficient, successful way.
I love how Aaron Bernstein facilitated that session and just so clearly laid out all the pieces for DPIAs as an example, and just supported with David Leduc at the NAI. I thought it was such a great session. One of the quotes that really stood out for me is when Aaron said, when you walk up to people in the business and you say, hey, do you process personal data? They're like,
What?
You want me to say no, right? You want me to say no, right? So yeah, there's an understanding of what they're doing in the business and how they're using data, and this that it's not just about compliance, but it's like, let me help you do what you're trying to do.
Right. I think that's right. Really, language is so important. I think as lawyers, we get comfortable with these statutory defined terms, but your audience, this is not, they're doing something very different. And if you're using terms and they have no idea what you mean, then you're losing time and you're absolutely speaking past each other. And so that's a pretty important thing to consider before you even approach those discussions.
Yeah, no, for sure. So we talked risk assessments and how to build a DPIA, the things to think about. We'll talk about that today. We talked about clean rooms, we talked about AI. I think we've talked about that a ton. So a couple of things. I want to roll through just a little summary of the DPIA section with you and get your thoughts on that, Elisa. Okay. And then also, in the comments, we're doing another one of these somewhere else in the country. And maybe it's different topics and people can kind of weigh in with, actually, I'd like to hear you talk about this or that. On DPIAs, what I loved is Aaron's framework, which was, okay, where are they required? When do they need to be done? What should they describe? Who gets to read them? And so as you kind of work through that, where and when are they required? Like in terms of states and activities.
Yeah, I thought it was really an interesting point he made that, yes, some states specifically require them, Colorado being an example, California is still working on their regulations, but I would get super practical. You're not doing it just for one state. At the end of the day, the FTC, for example, expects privacy by design, which is a risk assessment. And Colorado, I think, helpfully lays out particular topics that you need to do a DPIA for, and targeted advertising is at the top of the list. If you're using sensitive personal information, right, that is going to be something you need to do a meaningful risk assessment on. If you are doing automated decision-making, so generative AI is in the news, or making decisions that really impact people's lives in a legal way or other type of significant way, housing, education, then yeah, you're going to need to do a risk assessment. And so I think it's not everything. I mean, you have to do some risk kind of basic scanning when you're processing personal information for business reasons, but it's what's that at the top of that list in terms of organizing. And I thought he made the really good point, being strategic on, well, what's it? So let's say targeted advertising. Is it targeted advertising for every vendor? Is it targeted advertising for cookies versus something else? And I think what we saw and what the discussion in the room was, maybe you have a version 1, which is different than the version 2 a year from now or 9 months from now, when you've already gotten a whole bunch of these done, if you're just starting and really thinking about, is there a common category, right, where the facts don't materially vary? And so that might be a better way to bucket it, and a good, but just better use of resources if there's not such key distinctions between the practices.
I love that question. This idea of, okay, is it one? Can you have one DPIA that covers similar activities, or is it multiple narrow ones? And so you're saying, Elisa, yeah, you could have one that covers several materially similar activities, and when it changes, you update it.
Right. And or maybe it's 80% the same, but you have 20% where one vendor it's slightly different. Well, why not still have an overall DPIA, and you have your call outs and your distinct kind of, here's the additional part to that smaller piece. To me, that just seems like an easier way to manage, as opposed to doing separate ones for each partner.
Gotcha. And then so targeted advertising, sailor data, profiling, sensitive data processing, but then any heightened risk of harm to consumers. How do you, is there a test for that, or is there a guidance for what that means?
So the states exempt things like HIPAA and FCRA, right? So credit, health-based HIPAA-based decisions that impact insurance, for example, or medical care. But I put the lens on the FTC and what we've seen the FTC do. And at the end of the day, if you are using sensitive personal data, that's one way of going at it, that you would need to do a DPIA. But the other is just really thinking about what the business is doing is going to meaningfully impact consumers, either taking away options or giving them options. So I don't see that, for example, as like price variation for, kind of common retail stuff. I do think that on the risk spectrum, as you're doing things that do personalization in ways that might raise discrimination issues, I think that there is a whole area with this unfairness category on really thinking broadly on what discrimination means and negative impacting certain population groups. I think to me, that's where I think that's more likely to come up, just thinking really practically.
Gotcha. Thanks, Lisa. Related to that, this idea of who will read the DPIA, and when will they read it, and just specifically, like, what happens to attorney-client privilege in that scenario where regulators are, asking for DPIAs on a regular basis, and they can read those. I thought that was a fascinating conversation. Can you shed some light on it for us?
Yeah, so I think, look, there's always this age-old question of the privacy function, and is that in the legal department or is it out of the legal department? And we see companies do that in a lot of different ways. Attorney-client privilege is when you are providing protected, either the attorney working on your work doctrine, right, your work product, or you're advising the clients, providing legal advice to the client. And that is different, I think, from it's from facts, it's different from facts, and B, it's different from a lot of business functions that end up being operationalized compliance. And so the DPIAs, to be meaningful, you should have a component of that really is the result of attorney-client privileged advice, but the output, a lot of that output is going to be factually based compliance. And so the way that I think about it is, one, can you have an executive summary that really goes through all the core factual things? And that's like the smaller piece, which just is more efficient anyway, to have a quick way to look through all of your DPIAs. But then two, for the more in-depth ones, 80%, 70% of that probably is not privileged. Can you make yourself have an easier time by having the part that you want to have privileged communication, isolate that part, and not only isolate where it appears, but who has access to that part. I mean, that's part of the journey to get to your final DPIA product. But the whole thing, I think the ability to keep a whole DPIA privileged if challenged is probably not very high. And we've already heard from many of the offices, like they're going to expect that you to produce it. They don't expect, they've made comments that you're not waiving attorney-client privilege, but I would not rely on those kinds of representations. I'd put that control in your hands on what you intend to treat as privileged and have really good reasons for doing that.
Gotcha. Awesome. And that's what I loved about this session, because, frankly, I was worried about doing a session on risk assessments because I thought people do hundreds of these all the time, like they know this stuff intimately, but there's so much new nuance to it in different states, and there was so much benefit in people just talking about what they're doing and sharing kind of how they think about things, and of course the perspective from Kelly Dry, which was amazing. So all right, so July 1st coming along pretty fast here. What can we expect from regulators, or what's in your crystal ball?
So July 1st, as we know, is the key date where the regulators get to enforce these new laws in many of these states. And we had already heard months ago from California, for example, saying expect some letters going out on July 2nd. We don't think that the other states that have new laws are going to sit idly and quietly by. So my expectation is that we are going to see a whole lot of press releases, and these are not supposed to be laws just on the books. They are going to enforce. My sense, if California at least was an example, and where we've seen some of the states just based on their commentary and their emphasis in the regulations, I think digital advertising opt-outs is still going to be a priority area. We have, for example, from CCPA, we went to sale or share, and companies are still dealing with that in creative ways. So I expect we're going to see more letters in that space. I think there's been a lot of focus on health information, and I can imagine that's a sensitive personal information that we're going to see regulators also focus in on that topic. And then finally, I do think we're going to see DPIA curiosity by some of the regulators, particularly Colorado. I can imagine asking businesses about that. I don't think that the first round of these kinds of investigations are regulators going out to sue companies. I don't think that, but I do think that these letters and asking what you are doing to comply, how you are addressing, I do think that there's going to be a decent amount of dialogue. I'm watching for any published business guidance that might go up, interviews with different representatives from the state AG offices. And then, of course, seeing what the California Privacy Protection Agency, they've got rulemaking, they've got these monthly meetings. Are they hiring the auditors? Is there going to be that audit function where companies need to turn over, right, their risk assessments? And what does that process look like? How do we keep that, forget the privilege part of it, just confidential? There's like pretty sensitive business proprietary information in those risk assessments, and just really thinking through, once CPPA starts that audit function, how that is all going to work and how businesses are going to maintain the confidentiality of their materials.
I never thought I'd say this, but it's like actually pretty exciting.
I am biased, but I think it's I think it's just really interesting. I mean, look, at the end of the day, it's about data, and data supports business. It supports strategy. It supports intention. It supports trust. And it's really important to do it right. So we have gravitated to this field for a reason, but I think it's just it's in prime time.
Awesome. Well, looking forward to staying tight on it over the coming weeks. Thanks, Lisa. I appreciate your time.